Hello, and welcome to another episode of Ready Real Estate and Divorce Plus You. And from time to time, we like to bring on special guests on our show to talk about different areas, different topics, things that might be current, things that people might be thinking of, whether it be in real estate transactions, mortgages, divorce. And something that comes up frequently, a frequent question for me through my divorce clients is regarding estate planning. When should I start thinking about that? If somebody already has a will or already has an estate plan, should I change it before the divorce before I start the divorce? Before the divorce is complete, after it's final, and what do I do? And most of the time, everything has to stay as is until the divorce is final. But when it comes to estate planning, we prefer to send our clients to somebody that knows estate planning, that's what they do, a lawyer that is specialized in that area. And today we have Matthew Tavi. We're happy to have him. Matthew is an estate planning attorney, among other areas, but that's his forte. And I've gotten to know Matt, and he truly cares about his clients. Seems he is knowledgeable, and he's here to discuss this topic with us today. So, Matt, can you tell us a little bit about yourself?
No, absolutely. I'm honored to be here. I'm happy to be with all you guys. Thank you so much for having me. So again, my name is Matthew Tavi. I'm based in Birmingham, Michigan. I'm an estate planning attorney primarily for higher net worth individuals and business owners. Do a lot of real estate deals that kind of come along with that estate planning as well. And I couldn't agree more with what Jeff said in terms of the divorce clients that we get and how their estate plan is affected both before and after the divorce. So again, I'm happy to be here. I've been practicing for about 5 years now. I've been in Birmingham on my own for about 3 years. And business is great. I'm right down the street from Jeff's law firm as well. So, yeah, again, happy to be here, though.
All right.
Thank you.
Yeah,
What is the name of your law?
Tavi Law, Tavilaw, Tavi Law.
Okay, perfect.
Mm-hmm.
And Matt, can you explain to us exactly what an estate plan is? Because I think there's a lot of people out there, and professionals included, that sometimes don't really understand what that means. What does that mean to you, or what should that mean to people?
Right. So an estate plan, when you think of it, is basically an overview of the documentation that's going to help your family in the event that you become incapacitated or in the event that you eventually pass away. So when I think of an estate plan, for most of my clients, on a basic level, it's going to be a revocable trust, a living will and testament, and then powers of attorney, both healthcare and financial. So that's kind of the broad overview. So the revocable trust essentially guarantees that your family and your loved ones are going to avoid probate court. So your assets are going to flow into the trust, and then they're going to go to your children, your grandchildren, your significant other, without the headache and the stress of probate court. The powers of attorney, both financial and medical, those are going to ensure that in the event that you become incapacitated, so still alive, but just in a car accident or in the hospital, something like that, your significant other or your children will be able to kind of manage your day-to-day decision making without any hiccups or with any court battles or anything like that. So again, to kind of answer the question, an overview of the estate plan is going to be a revocable trust, a living will and testament, and then powers of attorney.
Okay. So, a lot of times people wait until they get older to do a will. Sometimes people do one early. What do you see is most common, and what do you think people should be thinking about?
Right. So I think it's kind of a variety, but I would say what you should be thinking about at all times is, significant moments in life. I think the estate plan should be at the top of your head. So marriage, for instance, is going to be a critical juncture to get an estate plan, because now, you have marital property issues, you have jointly owned assets. The birth of a child is going to be another major milestone in which an estate plan should be at the forefront of your mind. Divorce, another critical juncture in which after the divorce, an estate plan should definitely be either updated or just completely redone or implemented to begin with. And then just getting older in life too, essentially, as other assets are gained, the estate plan should always be on the focus of your mind. So I'd say any major milestone in life, especially when it comes to jointly owned property or property that was jointly owned but is now separately owned, the estate plan should be on your mind.
Go ahead, Holly.
I was just going to say, so a sticky situation, as you were talking, that I was thinking is, because we talk about divorce a lot, people get remarried. So as you're talking, I'm thinking, how nice is it if you have this done after the divorce, you update it like you said, so that if and when you do find that next person, it's not an uncomfortable situation of them asking you, what are you doing? How are you doing it? You kind of already, like if you want your kids to be your beneficiaries, you kind of already have that set. But if you want to tweak it, you can. But it's nice if you've already have that done. So it's like, for me anyways, I've been divorced 10 years and I don't know if I'll get remarried ever, but I want my kids to be my beneficiary. It's nice for me to know that it's solidified, if that makes sense.
Absolutely.
What do you
absolutely.
think about that?
I think you hit it on the head. I think a lot of the reason that I think people put off the estate plan is because of the uncomfortable nature around it. They're thinking about, major milestones that are kind of scary, whether it be death or incapacitation or divorce, something like that. So, but I think you hit it on the head. I think when you are divorced, having it done already makes that conversation much easier. You're going to feel secure, especially when you get a new significant other. At least knowing that that's already done is a huge relief, I think.
Right.
Definitely.
And you can update it if you want, but you could always just be like, oh, I already have that all set.
Exactly.
And
No,
it's
exactly.
not a,
You don't have to talk about
I'm in the
prenup,
process.
everything's in the trust.
Right.
It's cleaner.
Yep.
Much cleaner.
I would say if I had to put a term to it, it would be cleaner. The one thing on the mortgage end, I see a lot of individuals say, well, the house is in a trust. I can't refinance. Well, you can refinance.
Right.
And yes, you can purchase a house and then put it in a trust. That will by no means hurt a mortgage aspect, but that's what I've heard through a few clients that we've refinanced clearly while the house was in a trust. We just need the trust documents.
Exactly. And
It's
I think
easy.
we get calls all the time with people saying, hey, I'm about to refinance or we're about to buy a home. How do we put the home in the trust or how do we refinance it out of? So that's definitely it's a hurdle that's very easy to jump, I would say.
Very small, but just the word trust, I feel is equivalent to the word escrow. When you hear the word escrow, a lot of people are like, well, what does that mean? Even a trust. Now, for my example, my mother, we don't have a trust for her, but I'm in a ladybird deed.
Perfect.
So because there's not much assets that she has one major asset. The rest, I do have durable power of attorney in case something does happen to her. So that comfortability of just having that conversation just makes the rest of the conversation go so much easier. Because when I flew down to Florida, I'm like, let's just take care of this. And she's sound of mind. She's healthy. She's young. But because we were there together, like, let's just do this and let's do this right in case something happens. What if you get into a car accident? What if? Having that, because with the durable power of attorney, I have the ability to be able to sell her real estate.
Right.
I'm able to go into her bank account, close things, start new ones, what's the difference between the two? There's the power of attorney and then durable. What is the difference between the two? Or am I wrong?
It's essentially the same thing. The durable power of attorney, usually the biggest thing with the power of attorney is deciding, one, who it's going to be and when it's going to become active. So like a durable power of attorney with your mother, not assuming, but you probably have it so you could act immediately if she were to become incapacitated, as opposed to have physicians deem her incapacitated, which would kind of take some time. So that's usually the main distinction there. But I mean, you hit it on the head too. I think a lot of people having that initial conversation is difficult. People put it off, but it's very straightforward. Like, I mean, when you got the ladybird deed done, for instance, I'm assuming you did that in one day.
Easy.
Exactly. So, and then the stress that's relieved from that is just, I mean, you can't put a price on it.
It's out of sight, out of mind. And what's comfortable is I know where my mother stands with her wishes and what she wants done with the property. And I'm wholeheartedly going to do what she wants.
So, something that you brought up that I think is important, or something that I thought of now as you were talking, is your mother's wishes. You said your mother's still young, still healthy. Something that I see, unfortunately, sometimes is when people are not so young, not so healthy, and maybe make a decision based on potentially influence of who's living in their house with them, which child is taking care of them the most, which child is spending time with them or playing cards with them or whatever. All of a sudden, other siblings want to challenge that and say that's unfair, that wasn't right. And then it's hard to say, then, okay, is the person who designated who they wanted to be beneficiary, who they wanted to be power of attorney, were they truly all there? Were they of sound mind or not? So that's something to really... And I know, listen, we all want to avoid thinking about these things, but it is something important to think about before you get to that age, so that way there aren't those issues. And there's been cases that we've litigated in the past where Could be, was that really their true intent or not? And it gets messy, and that divides families, and it's no fun. It really isn't.
No, absolutely. I think the best way to overcome that hurdle, right, to kind of get over the incapacitation or the sound mind argument is a history. So if somebody's updated their estate plan for years and decades, it's
Establishes that
they've
history.
established a pattern
Okay.
of thinking about this, as opposed to, and we do get calls quite often of people who are later in life and are like, hey, I need to get this done immediately. And that's where kind of you get into that dicey or potentially litigated down the line, just because of the, the quickness of
But
it. Maybe
it's
they
still
don't,
probably better to have than not, right?
definitely better to have than not, because I mean, it's expensive to litigate something. So the people who are trying to litigate would have to, have a very serious reason to do so. But yeah, I mean, the earlier you do it, the better. It shows a pattern of thinking about these things, of, having your intentions on paper as time goes on. And it makes it much smoother even after the fact, too, to administer everything, because it's, we have a relationship with the client and we've kind of known them for quite some time. We know their affairs and we know, the family dynamic, essentially. So
if there's if there's a trust in place when a couple goes through divorce and the divorce is finalized, but the trust isn't addressed, and one of the couples passes away, does that trust take precedent and the assets distributed within the trust under there? But I would imagine it's probably something's going to happen in that point, right?
it can't. So I mean, that's the biggest reason for after a divorce is like one of the most critical times to update the estate plan. Not only the estate plan, but just to take a broad look at your finances and figure out. I mean, a lot of times we get calls, people will say, oh, my husband's name is still on the deed of the home, or my husband's name is still on my life insurance designation, like as the beneficiary, or just that kind of stuff. And if your husband remarries, or if your significant other, is even just out there single, if you pass away, they're going to get that money. If you pass away with that trust still in place, they're, potentially liable to be in charge of administering your estate, be your trustee. So updating the powers of attorney, the will, the revocable trust, updating the property deeds, the beneficiary designations is so critical after the divorce. And it takes like an hour to just do a quick inventory of, what do I have? Where do I have it? Who do I have on it? And then if it needs to be redone, just call us. It's very
Do you review those, Jeff, when going through people with divorce clients? Do you ask them about the trust then? And
we'd like to know if they have one, what they have, how it's set up, and we do tell them that it's important to meet with an estate planning attorney to start thinking about what they want to do, and then after the divorce is done, then to go ahead and move forward to be able to change it to however they want it. Obviously, if it doesn't conflict with the terms of the judgment.
Right.
A lot of times there's certain things in the judgment that they might have to keep in place to secure support, to secure property, to secure payments of some sort. But to the extent that they're allowed to change anything, they probably should. Otherwise, it's a question of what could happen. So it's smarter to do and to be thinking about. But, a lot of times people will start changing stuff after they filed for divorce. And that's usually a violation of a preservation of assets order, potentially status quo orders. You can't change anything unless it's mutually agreed upon and signed off by a judge or ordered by a court to be changed until after the divorce is done.
Okay. What about strategy? Let's talk about strategy for a moment. A female knows that she wants to leave her husband
Okay.
or wife, whatever the relationship is. What if she knew this like 2 years prior or a year prior? Is there a time that you can't change stuff knowing that you're setting up for divorce? Or could you argue that they knew and this was a strategy of theirs by chance? Let me just throw that out there. I know that's a hairy conversation.
Let me take that first. So here's the thing. If somebody did it a while back without the intent of defrauding their spouse or hiding marital assets or dissipating any sort of marital assets or moving something away, then okay. And if your spouse knew about it, then usually it's probably okay and accepted. But if it's done right before the filing of a divorce, in contemplation of that divorce, then you could potentially have to pay it back or figure out how to make it whole again, or potentially get punished and pay more than what you would have otherwise.
Do you see?
I would agree with Jeff completely. I think it's a timing issue there. If it's right, the sooner it is to the actual filing of the divorce, the more suspect it's going to look. But yeah, I think 2 or 3 years prior, I would say is probably
And
Say,
it
depending on
depends
the
on the
situation.
circumstance.
I'm not trying to educate how to
No,
lead the
no,
situation.
no.
But
It's
like,
never. Listen, it's never advisable. It's never smart to do. It's unless you have an agreement with your spouse, with your partner, on what you're going to do and on that estate plan while you're married. Otherwise, if you try to hide something, it could come back to bite you in the butt hard. So, the best thing is honesty, transparency all the way through.
and with having an amazing attorney with Discovery, you'll find it.
I mean, almost everything can be found. Truth eventually comes out. So,
Absolutely.
Always the best policy.
No.
No, what his question was basically what I was going to say is, I'm thinking, so now I do have a trust. Let's say that I was married and we put the trust together. Is it harder? I was just thinking, is it harder going through the divorce to dismantle a trust, or is that, because then you've got to dismantle the trust and then set it up again on your own, kind of a thing.
Right. It's I mean, like so Jeff said, after the judgment of divorce is finalized, we would take a look at the judgment, make sure that your strategy doesn't conflict with the judgment at all. But then it's pretty straightforward to just essentially revoke, because it's most likely a revocable trust that you were dealing with prior for most people. So we would just revoke the original trust, kind of nullify it, and then we would put a new trust in place for you right after. But no, it's not. I would say it's no more difficult than it was the first time around. Probably even more simpler this time around, actually, because you probably have half of the assets that we're dealing with. But yeah, I would say no, it's no more effort than it would be originally.
Okay.
Definitely.
So
Good to know.
if you can't, don't have the time to redo the trust right away, is there something right after you get divorced just to dissolve the existing trust right away? So
Yeah, definitely. So it's essentially just a few page document, just nullifying revoking your original trust as a settler. And then, the quickest thing you could do too, if you didn't want to come to the office or meet with an attorney and completely redo your new trust, you could just essentially take a look at the beneficiary designations. So after the divorce is finalized, you have the judgment, look at your life insurance. Who do you have on there? If you have the old trust and we just nullified it, take that off, put, maybe the kids' names on there. Again, assuming it doesn't violate the judgment of divorce. But same thing with the real property deed. These things can be changed very quickly. So just looking at the beneficiary designations on everything, I would say, would be the quickest way to accomplish, the same goal of ultimately redoing your estate plan, just in a quicker manner.
and it's important not just immediately upon getting divorced, but sometimes it could be annually after that, or because certain judgments of divorce, what we put in there to secure the payments of whether it be child support or spousal support could be a life insurance policy, right? Whether it's an existing life insurance policy or they have to take out a new life insurance policy, the person is responsible for paying the support, but that's on a declining amount enough to secure the outstanding obligation that they still owe. So assuming, say you have $1 million policy and you owe $900,000. So that other 100 you can have another beneficiary of. Then next year, say you're paying $100,000 a year. Next year you owe $800,000. Then rather than keeping that whole $900 to the person that you owe, you can go back and reduce it. Is that correct?
Absolutely.
Matt, something you can do like that?
So if there's
Absolutely.
a spousal support order, that's a question that is almost like a lien against a life insurance policy if that passes away. Because if there was spousal support, would they have to?
In the judgment of divorce, not always, but in the judgment of divorce, sometimes support is secured one way or another.
Okay.
And the most common
I
way
didn't know that.
it's secured is through life insurance.
Okay.
Yep, absolutely.
Depending on how much the amount is, what the circumstances are, the employability, there's a lot of different factors on how to secure that. But yeah.
Yeah, absolutely. Absolutely. The divorce is a big one. The birth of a child is a big one. And then I would say, just later in life, I think, the real estate deals are a big one too. 'Cause you have to remember when you do have an estate plan, it should be updated whenever you have a major purchase. So you guys are constantly selling homes, selling mortgages and whatnot. So the new home should always be in the estate plan. That should be in mind. A lot of people run into that problem. Again, an estate plan is only as useful as it applies to your life. So if you do buy a new home and it's not in the trust or it doesn't go to the trust via ladybird deed, it's going to go to probate court. So it's important to keep the estate plan in mind at all times, especially when you're purchasing, major pieces of property or, opening investment accounts and whatnot. Everything should be with the estate plan in mind. So I don't know how often you guys run into that problem where people buy a house and forget that they have a trust or...
Oh, no, we find that eventually in title, and then we're scrambling when someone gives us a phone call. This isn't a trust. But the big thing is if any good loan officer and real estate agent would look at the public record.
Right.
And in one local one that we look at as BSNA, we can see who's holding title. And
Right.
it will typically say trust. Unless the county hasn't updated their record, that's where we kind of get smacked
Right.
sideways, like, whoa, they didn't mention it. It's not in public record.
Right.
We'll get, I think I've only had one that kind of smacked me sideways. Like
good.
right at the end, it's like, then we need the trust and we need to update the documents and then go from there. Maybe a 2-day setback. But again, if we move quick, it's
Yeah.
okay.
No, it's great that you're looking at that too for the client. That's
absolutely.
fantastic. That's a huge,
Well, I
huge asset for
I
them.
like to see the full picture. And as you're building and talking to a client, when I do puzzles, for example, I am the edge puzzle person first. I have friends who group them in color first.
You wanna fill it in.
I'm the edge. It's like that's when I first initially talk to you. Then when all the documents come in, I start grouping by color. Like, okay, here's the income, here are the assets, and you start building this picture. And if there's a trust that comes out of nowhere,
Right.
you got to take apart that bottom left corner or
right.
bottom right corner and go, okay, let's restructure this.
Right,
Different hues of green don't go. So it's fun. It's fun. But no, we typically see it up front. Now, if you're working with a professional, you'll ask for it up front. There are individuals in every industry that don't ask questions.
Right.
So that's huge with having you here, what questions our audience can ask regarding a divorce, regarding a trust, real estate, mortgages. This does bring up a lot of questions that they can actually contact you and us after viewing the podcast.
Absolutely.
I got a question. So many people out there do not have a trust. And I know it does have to go to probate, my understanding, and right, no matter what. But what can you do? Do you send yourself, like if you have these things and you have certain intentions that you'd like to happen, but the trust is not there, would you sense, is there something you can do to secure yourself or to secure your intentions, like even just by sending an email to somebody you trust? Or
Right. So the best way, so anything is going to go to probate if it doesn't have a beneficiary on the account, right? So I have a Chase bank account, for instance. If I pass away tomorrow and there's nobody's name as the beneficiary on there, it has to go to probate court. The probate court will then decide, after 5 or 6 months, who gets that account. So the best way to do it without an estate plan is to simply make sure all of your accounts, your property has somebody's name on there as a beneficiary. You can do that without a trust. A trust is essentially like a layer of protection. So let's say I have 3 young children and I have millions of dollars. I'm not going to put their names on my Chase bank account with millions of dollars, because if I do that and pass away tomorrow, they're going to inherit that money when they turn 18. And sometimes inheriting millions of dollars at a young age can be the worst thing that can happen to somebody. So what I would do is have my trust as the beneficiary. The trust will say, hey, give it to the kids when they turn, 25, 26, 27, or do a W-2 match every year. A lot of my clients do that. Whatever they make,
that's cool.
Bring your W-2 to the
Oh.
trustee. The trustee will just match it.
Well, I like that. Then I can make a
That's
$500,000 and get my
smart.
million there,
Exactly,
like
and
double down.
It kind of incentivizes the
incentive.
kids to not just say, oh, I have a trust fund, I'm going to be making, whatever it is, $1 million a year from that. It kind of incentivizes them to, go after it. So, but again, other from actually having an estate plan, I would say just the biggest thing you can do, is the deed to your home. So the deed to your home, usually when you purchase a home, it's just, Matt and Rebecca, husband and wife, own their home. That's it. The best thing you can do is a ladybird deed, which is what we do for basically everybody, depending on the circumstances, which just says, Matt and Rebecca own the home, husband and wife. In the event that Matt and Rebecca pass away, the Matt and Rebecca trust becomes the owner. And then there's no probate court. It goes to the kids, however we decide to split it. So that's the best way to do it. I would say update the beneficiary forms in real time, always.
yeah, so much that you need to know, and
Well,
you don't
It's a lot.
know what you need to know until
Exactly.
until you watch our
something
podcast.
comes- so something comes along.
Until you
Exactly.
watch this.
And we know
Right.
it's not really an exciting topic or something people want to
Exactly.
think about. And that's something I tell my divorce clients right away is, listen, things, as bad as things seem now, the reality of it is they could get worse. They probably will get worse before they get better. Eventually it will be better. But along the way, there's going to be a lot of things to think about and focus on that you don't want to think about. But it's stuff that has to get done to get you through to plan for where you need to be, so then you can move on the proper way.
Right.
So we appreciate having you on
No,
today.
happy to
And
be here. Happy to be here.
Matthew
Thank you.
Tavi,
Thank
if
you so
anybody
much.
has any estate planning questions, he's the guy to call.
Perfect. Thank you for
And
having me.
all his information will be on the very end and then down in the comments. I can imagine we'll be posting it everywhere. So
Perfect.
Matt,
Thank you guys. Thank you for
Thanks,
having me so
Matt.
much. It was a pleasure.
Thank you for everybody tuning in, and we'll see you next week.